Hi guys, I hope you all are doing well. This is Sahajpreet and you're watching Legal Bites. In today's video, we'll be learning about the legal maxim Injuria Sine Damno. In this video, I'll be covering the meaning and origin, explanation, application, a few illustrations and case laws to understand the maxim better. So let's get right into the video. Starting with the meaning and origin of the maxim Injuria Sine Damno. Injuria Sine Damno is a legal term of Latin origin, and in Latin the maxim literally means injury without any damage, which means legal injury without any damage. Moving on to the explanation of the maxim. So, Injuria Sine Damno means that there has been an infringement or injury to the legal right of the person without any damage to the person or property. And when this happens, the person has a right to sue the other person in the court of law, since there has been a legal injury. And even if the damage hasn't been there, the person has the right to sue. Moving on to the application of the maxim. So, as we all know, everyone has absolute right to their property, personal freedom and immunity, and any infringement of this personal freedom or immunity or any threatening to infringe the legal right of the person can sue the other person in the court of law. Some examples of this can be trespass or even wrongful detainment of a person. Next up is an illustration. So, A was wrongfully detained by B. Now, in this case, A did not suffer any injury or any damage because of this detention. So, the question which arises is that can A sue B in the court of law? The answer is yes, A can sue B in the court of law, since whether or not he suffered any damage does not matter. What matters here is that there has been an infringement of A's legal right, and that gives him a right to sue B in the court of law. Next up is the very famous case of Ashby versus White. So in this case, the plaintiff is a qualified voter and the defendant is a returning employee. Now, when the plaintiff was going to exercise his right to vote under the law, the defendant refused and did not allow the plaintiff to vote. However, the person who the plaintiff was going to vote won the elections. So does this mean the plaintiff no longer has the right to sue the defendant under the court of law? The answer is no. The plaintiff still has the right to sue the defendant under the court of law, because हमने यही पढ़ा ना कि damage हो या ना हो उससे मतलब नहीं है. If there has been an infringement to the legal right of a person, the person has the right to sue the other person in the court of law. So that was it for today's video. Thank you so much for watching the video. Do not forget to like, share and subscribe to the YouTube channel. Additionally, there's an article on the maxim, the link to which can be found in the description box below. Thank you.